All right, ladies and gentlemen, it is 4:30, and we like to start things on time here. For those of you who don't know me, I'm Michael Scharf, the co-dean of Case Western Reserve University School of Law, and it is my great pleasure to kick off the annual Klatsky Endowed Lecture in Human Rights. This lecture has been endowed by one of our most prestigious and supportive alumni, Bruce Klatsky, who lives in New York and was sorry that he couldn't be here this year to do an introduction. But Bruce started this 17 years ago, and it was his idea that this law school should have a dedicated lecture in human rights. And we, for the last couple of years, have been tying this together with our annual Global Award for Advancing Humanitarian Affairs. Its actual title is the Frederick K. Cox International Law Center Humanitarian Award for Advancing Global Justice. And so every year we give this to a luminary in the field. And the people who have gotten this have included the High Commissioner for Human Rights, Prince Zeid, a couple of years ago. And we've had the legal advisor of the State Department. We've had International Court of Justice judges. And today we are very, very happy to give this award and have a lecture by a very old friend of mine, Sean Murphy, who I met when I was a junior lawyer at the State Department. He was a bit more senior than I. We both ended up going into academics. He has risen through the ranks and become the United States expert on the International Law Commission, which is the UN body that codifies international law and creates new treaties. And he's also recently been elected the president of the prestigious American Society of International Law. And my prediction is you keep your eye on this guy because he will be the American judge on the International Court of Justice in just a few years. Every position he's ever had, he's got the golden touch and he does a fantastic job. He's got a sterling reputation in the field and he's a wonderful speaker. So you are in for a treat. This is the 27th year of the founding of the Cox International Law Center. And over that time, this law school has been very fortunate to be able to host these kinds of conferences and lectures. And we are recognized nationwide and worldwide for our programs. I see that we have several of our renowned international law professors in the room with us, and together they have really elevated this program and brought Cleveland, Ohio, onto the international scene, such that we are ranked 12th best in international law by our peers throughout the country. So without further ado, I'd like to present this wonderful award to Sean Murphy and have him kick off the 2018 Klatsky Lecture. Sean.
Thank you so much. Thank you. Well, thank you very much, Dean Scharf, for that wonderful introduction. It felt a little bit like you were reading from my mother's diary as you reeled off these things, and I'm glad you didn't get to the part about always did his homework in the second grade or something like that. But it is really a great pleasure to be here today and to give the Klatsky Endowed Lecture on human rights. It's a great pleasure in part because it's an opportunity to see Case's students and faculty and alumni and friends of the law school. But it's also a great pleasure because Dean Scharf is absolutely right that Case has made a footprint in the field of international and comparative law that is well recognized and understood across the country and indeed around the world. I think that the kinds of programs that have been operating here over the past 15, 20 years and that are bringing people to Cleveland as well as pushing out the information in various forms of media is really quite striking, and I think it's been well noticed, as I say, not just around the country, but around the world. So it's a great pleasure to be here and to be a part of that, and to receive the Center's Humanitarian Award for Advancing Global Justice is also a wonderful thing. I'm not entirely sure how I slipped past your selection committee, but I'm appreciative that I did. And as Dean Scharf said, the the talent of the faculty here in international and comparative law makes such a selection even all the more special. So thank you very much for that. My topic concerns the International Law Commission's proposal for a convention on the prevention and punishment of crimes against humanity. And I thought what I would do is talk a little bit about the origins of this concept of crimes against humanity, then just touch on the fact that we do have these crimes happening around the world today, and my strong sense of where we are weak in the field of international law and international institutions in addressing these crimes, which is all lead up to then talking a bit about the International Law Commission's project to do a new treaty that will address these matters. So starting with the sort of historical emergence of this concept of crimes against humanity, basically if you go back about 120 years and you look at things like the 1899 and 1907 Hague Conventions, dealing with issues such as the laws of war, you do see glimmers of this idea of crimes against humanity, in particular in the Martens Clause, that was a preambular clause in those treaties. You see reference to the laws of humanity and the dictates of public conscience as being an idea that should help animate the development of laws of war. And that idea of there being heinous conduct that needed to be regulated because of our humanity and what our humanity means began to flower a bit in the period of the First World War, because then is when we started hearing calls for leaders of defeated countries, Germany, Turkey, to be prosecuted for crimes against humanity. And wasn't entirely clear what that meant, but it seemed to be thinking about and worried about attacks on civilians as opposed to armed conflict between two belligerents that might have bad acts occurring along with them. Unfortunately, I think the First World War did not lead to any significant prosecutions, including prosecutions for crimes against humanity. There was a bit of talk about it, but ultimately the Treaty of Versailles did not include crimes against humanity as one of the types of crimes that could be prosecuted. So it's only after the Second World War that we really have a full-blown emergence of the idea of crimes against humanity. It's incorporated in the Nuremberg Tribunal, Charter for the Nuremberg Tribunal. It's incorporated in the Tokyo Charter for the Tokyo Tribunal as one of the types of things that you could indict someone for. So you could indict them for war crimes, you could indict them for the crime of aggression, you could also indict them for crimes against humanity. And several of the senior and mid-level leaders in Germany were in fact investigated, indicted, prosecuted, and successfully convicted for crimes against humanity. Again, the nature of the crime is essentially attacking a civilian population. In that context, though, it was in connection with an international armed conflict. So the attack on the civilian population per se was going to be widespread in nature, in all likelihood, because of its connection to an international armed conflict. So you had to make that connection when you prosecuted individuals, although at times it was somewhat tenuous, the connection that was advanced. So after Nuremberg and Tokyo, there's a hope that maybe crimes against humanity would be fully ingrained in international law and would be allowed to develop even further through the creation of a permanent international criminal court. In 1946, the General Assembly adopts a resolution that basically welcomes and adopts the Nuremberg principles that were in the Nuremberg Charter. In 1950, the International Law Commission codifies those principles further, and also in 1954 develops a thing it calls the Draft Code of Offenses. That's all fine. It basically helped develop and refine a bit what was meant by crimes against humanity, but it did not go hand in hand with the creation of an international criminal court. We are unable, in the Cold War period, 1950s, 1960s, 1970s, to develop a permanent international criminal court. So instead, to the extent crimes against humanity are being addressed, it's happening at the national level. Some states adopt national laws on crimes against humanity. Some states proceed with prosecutions of individuals for crimes against humanity. But you can somewhat count those cases up on the fingers of your two hands. You're probably aware of the Eichmann case in Israel. You may be aware of the Barbie case in France. These cases did happen, but they were relatively modest in nature. You get to the end of the Cold War, and a little bit of a dam breaks, because in the 1990s, suddenly we are able to create international criminal tribunals. We have in 1993 the creation of the Yugoslav War Crimes Tribunal, 1994 creation of the Rwandan War Crimes Tribunal. We have also some hybrid type tribunals being created, Special Court for Sierra Leone, extraordinary chambers in the Cambodian courts, and so on. And in 1998, with the adoption of the Rome Statute, the creation of a permanent international criminal court. All of these courts, there's one or two exceptions, but all of these courts have as one part of their jurisdiction crimes against humanity. So again, the crime is being articulated, it's being embedded in these tribunals, people are being prosecuted for it in The Hague, elsewhere. That's a very important step. It's something to be celebrated and to be analyzed and to be improved to the extent that we can. But at the end of the day, notwithstanding those successes, when you look at the actual numbers of people who can be prosecuted before international courts and tribunals, it is a very modest number, and it's very expensive. You're creating entirely new institutions with people, investigators, prosecutors, judges, courtrooms. I helped, as a US government lawyer, set up the Yugoslav War Crimes Tribunal in The Hague when I was based there for 3 years in the mid-1990s. It's unbelievably expensive to do this. It's not a reason not to do it. There are values served by having a place where you can prosecute senior leaders and so on. But it's very difficult to put all of your eggs in that basket. When we look around the world today, we see crimes against humanity occurring on a significant scale in a number of different places. With this audience, I don't think I need to talk a lot about that, but you don't have to go very far to think about North Korea, hundreds of thousands of people in political camps being murdered, being starved, being raped, being forced into labor. You don't have to go very far to think about Syria, upwards of 500,000 civilians killed in the past 10 years. Sudan, Darfur, we all know about that, probably roughly 200,000 civilians. These are not civilians killed as incidental harm to a lawful military action. These are civilians who are simply being killed, mistreated, abused because there's a political objective in going after them. So it's happening on a significant scale, and it's not just states doing it. We've got non-state actors doing it as well. ISIS, ISIL, Daesh, whatever you want to call it, the Islamic State. We've all seen those videos of people being beheaded. We've heard about the attack on the Yazidis. We've heard about attacks against Iraqi soldiers where they're just being slaughtered, even when they've laid down their arms, things of that sort. So non-state actors are also capable of committing crimes against humanity, attacks against civilian populations. And the existence of international courts and tribunals may be a part of the solution to this, but I would submit that it's not the full solution. So where might the full solution lie? I think we need to be taking seriously the need to build up national laws, national jurisdiction, and the ability of states to engage in interstate cooperation in support of national prosecutions through things like extradition, mutual legal assistance, and so on. My university did a study in 2013 where we attempted to look at all of the laws, national laws worldwide on crimes against humanity. It's a very interesting study. It's up on our website at GW if you're interested in seeing it, but let me just give you a few of the basic statistics. Half of the world, half of the countries of the world have no national law whatsoever on crimes against humanity. We're sitting in one. The United States has no statute on crimes against humanity. We have one on genocide because we joined the Genocide Convention, so we adopted a genocide implementation statute. We have one on war crimes because we ratified the 1949 Geneva Conventions, which addresses war crimes. We have no statute in the United States on crimes against humanity. Half of the world, it's the same story. Even if you look at countries that have ratified the Rome Statute, which you might think would have led to the adoption of national laws on crimes within the scope of the jurisdiction of the International Criminal Court, of the Rome Statute parties, a full 1/3 have no national law on crimes against humanity. Why? The answer probably is there's no operative provision in the Rome Statute creating the International Criminal Court that obligates a state party to adopt national laws. There is an incentive. There's this idea of complementarity in the International Criminal Court where the court will not proceed with an indictment and prosecution if one is happening at the national level. So you might want to build up your national law to, in part, avoid your people being sent to The Hague. So there's an incentive there, but there's no outright obligation. Many states parties to the Rome Statute have not adopted any national law on crimes against humanity. Even states that have adopted a national law, when you actually look at the law, it's startling how often it has nothing to do with crimes against humanity, meaning it has a title, Crimes Against Humanity. When you read the statute, it's actually about war crimes. That's particularly true of Latin American states, South American states. Even if it is on crimes against humanity, sometimes these statutes are pretty old. So if they were adopted in the 1950s, 1960s, it's got what you might regard as an old school version of crimes against humanity, not the very well developed, very sophisticated definition that exists now in instruments like the Rome Statute, particularly Article 7 of the Rome Statute. Even if the country has a national statute on crimes against humanity, and it's a pretty good-looking statute, gold-plated, whatever, it's striking how many countries can only exercise jurisdiction over offenders who are the nationality of that country or when the crime occurred in that country. So, if some bad actor, Pol Pot, let's say, stumbles out of the jungle in Cambodia, and if you try to look around the world, where can we prosecute Pol Pot for crimes against humanity? Many countries, even though they have a statute on crimes against humanity, can't prosecute him because he's not their nationality and the crimes didn't occur in their country. So this combination of lack of statutes, lack of jurisdiction is pretty pervasive, pretty significant in inhibition in the ability to prosecute people for crimes against humanity. Last thing I would say is, if you know about the way extradition works, mutual legal assistance works, you typically need the act at issue to be criminal in both jurisdictions, dual criminality. Otherwise, that extradition, that mutual legal assistance is not going to go forward. All right, so there's problems. How do we solve these problems? I am a member, as Dean Scharf said, of the UN International Law Commission. The International Law Commission is a group of 34 experts from around the world. They are nominated by governments, and then there's an election in the UN General Assembly. And some people win and some people lose. I'm the American on the ILC. There's only allowed one nationality per member. So I'm the American on the ILC. I was nominated by the US government twice. I was elected and then re-elected. In the course of those elections, you actually do have to campaign, right? So the first time I ran for the ILC, I met with 97 countries one-on-one to ask for their vote. I mention that in part because a question I would typically get after the niceties of saying hello and how are you is, okay, if we vote for you and you get elected to the ILC, what are you going to do on it? What's your idea for something the ILC should take up? It's a really good question, right? And if you can't answer that question, you probably shouldn't be elected. So my standard response to that question was to identify a little bit of what I've just talked to you about, this gap in the field of international criminal law / human rights law, this gap about lack of national laws and jurisdiction and interstate cooperation, and why don't we have the ILC draft a convention that will fill this gap? I guess it was not a bad answer to the question. I did get elected when I showed up in Geneva. It's 2 months every summer in Geneva. That's the job. Tough duty, someone's got to do it. 2 months every summer in Geneva. When I showed up in the summer of 2012, I make the proposal that we should be drafting a convention on crimes against humanity. The commission is very careful about the projects it takes up. It only does about 9 or 10 at any one time. So a lot of ideas come forward, many of them crash and burn. We talked about this for the summer of 2012, summer of 2013. In 2013, the commission decides, let's put this topic on our long-term work program. That is basically sending up a flare to the UN General Assembly that the commission is thinking seriously about doing this topic. If in the fall of 2013, the commission had, the General Assembly had said a lot of bad things about this topic, then we wouldn't do it. But as it turns out, in the fall of 2013, the General Assembly was relatively positive about it, so that when the commission comes back in the summer of 2014, we put the topic on our active agenda and appoint Murphy as special rapporteur. So my job then is to begin the process of writing a series of reports that roll out on an annual basis a series of draft articles for what will be in this convention, defending the language of them, explaining why we need it. So 2015, first report results in 4 draft articles that the commission debates, refines, and approves in the summer. 2016, second report, another 6 draft articles. 2017, this past summer, a final 5 draft articles plus a preamble and an annex. Meaning that at the end of the summer of 2017, we have a full draft treaty, preamble, 15 articles, and an annex. That's the completion of the first reading, first draft. We put that to the General Assembly in our annual report, and we wait 2 years. We give governments a lot of time to digest this. They react orally to us when they debate our work in the fall in New York, and they react in writing to us. So written comments are starting to come in from countries, what they like, what they don't like about the whole project. We will return in 2019 to do the second reading, the final version, based on fixes to what we've already done to try to accommodate the concerns that governments have expressed. Okay, Let me just say a little bit about what's in these draft articles so you have a little bit more of a sense of what the project's all about, and then I'll finish up by indicating where it might be going from here. So in the draft articles, we have a draft article 3 that defines crimes against humanity, and we have basically super copied the definition from the Rome Statute, creating the International Criminal Court, into our project. So it's kind of the modern version of what crimes against humanity are all about. We had some discussions, should we try to improve on the 1998 definition of crimes against humanity that made its way into the Rome Statute, and there are voices out there about ways it could be improved, but we decided not to for 2 reasons. One is that there's a lot of countries that support the Rome Statute, 123 states at this moment, and to the extent that we were to start doing things that differed from the Rome Statute, you begin worrying about losing political support. So, as all the lawyers in the room, and no doubt the law students as well know, you always want to have your lawyer, antenna up, but your political antenna should be up to a certain extent too, depending on what it is you're doing. So we didn't want to get crosswise with the Rome Statute. The other reason to keep the same definition is to the extent that we are trying to promote complementarity. That is the idea that at the national level, it's fine to prosecute the person and then they won't end up in The Hague. All the more reason to have harmony between what happens in The Hague and what's happening at the national level. So, same definition appears in Draft Article 3. Draft Articles 4 and 5 of the project talk about prevention of crimes against humanity. Us lawyers often think about prosecution, punishment after the fact, but of course we also care about prevention ab initio, so that we don't even get to the prosecution side of things. So what are ways in which we might promote states in training military personnel, training police personnel, and so on, with respect to why crimes against humanity are not a good thing to do, right? We already have this in the context of war crimes. If you're familiar with the military manuals that many countries have, training programs by the ICRC and so on, the idea is we need to be doing that as well for crimes against humanity. Draft Article 6 is an obligation that you adopt that national criminal law. And it's a complex article. It talks about a statute that prohibits crimes against humanity, not adding up a bunch of statutes on murder, torture, and other things, but no, actually having a statute on crimes against humanity, stigmatizing the conduct in that way rather than cobbling together other types of things you might already have on the books. Investigating prosecuting people for commission of crimes against humanity, but also attempting, and also things like aiding and abetting crimes against humanity. So a fulsome way of dealing with the modes by which the crime might be committed. You have to have the statute that will address command responsibility, right? So if a senior military or civilian leader knows that these crimes are about to be committed by lower level people, you have to stop them. If you don't, you've just committed the crime. If lower level people go off and do the crime without your knowledge and you later find out about it, but you don't punish them, you've just committed a crime. So command responsibility, important element. Flip side of that, no superior orders defense. You can't, as an individual, say, my superior officer said, go off and do this. I was ordered to do it. That's my defense. No, the national law has to not allow for that superior orders defense. Likewise, you can't claim an official position as a defense, meaning you can't say, I'm the president. I couldn't possibly have committed a crime. No. You can commit this crime no matter where you are in the hierarchy of the government. No statute of limitations. on crimes of this nature, appropriate penalties for the crimes, and then finally, this was a little bit controversial within the commission, you also need to have a provision in your national law establishing the liability of legal persons. Think corporations or perhaps non-governmental organizations. Article 7, I'm not going to go through all of them, but I want to hit on the ones I think are particularly important. Article 7 requires you to establish jurisdiction when the crime occurs in your territory or on a vessel that's flying your flag, when it's your national who does it, and when an offender who's not your national somewhere else turns up in your territory. This is Pol Pot calling. He's very concerned about that now. But this is the idea that if the Pol Pot turns up somewhere, right, or maybe a better, more timely example, President of Chad, Hissène Habré, turns up in Senegal. If Senegal has joined this treaty, it now has an obligation to exercise jurisdiction over him if it's alleged that he has committed crimes against humanity. Okay, so we've got the statute on the books, we've got the national jurisdiction, and we've got the idea that when somebody turns up in your territory, you must exercise jurisdiction over them. There's then, in Article 10, what's referred to as an aut judicare obligation, an obligation to submit the matter to prosecution unless you extradite to another country or surrender to an international tribunal. So you have to prosecute. Well, you have to submit the matter to prosecution, slightly different from a flat-out obligation to prosecute. And you can only get out of that if you extradite or surrender the alleged offender to somewhere else. Article 12 on victims, witnesses, and others is something that if you're interested in, how do victims benefit from all of this? Can they speak at the proceedings against the alleged offender? Could they get reparations? We have a draft article addressing those issues as well. And then we've got articles on extradition, mutual legal assistance, and so on. Okay, I'm just going to finish by saying, where will this go from here? Okay, my prediction is, in the summer of 2019, the International Law Commission will successfully finish this project. We will complete a draft convention, and we will send it forward to the General Assembly. When we do that, we make a recommendation. My hope is the recommendation is to ask the General Assembly to either convene a diplomatic conference of states to take this draft and turn it into a full-blown treaty, or to negotiate the matter within the General Assembly itself, and specifically within the 6th Committee, which is the legal committee of the General Assembly. My hope is that we push them to do that. My further hope is that there will be a group of states that will champion this project, because we need the governments to be excited about it and to push it forward. In which case, maybe, if all goes well, in the fall of 2019 or shortly thereafter, the General Assembly will, in fact, decide to convene that conference or negotiate the treaty within the Assembly itself. My hope is that then we successfully transform this draft treaty into a treaty. That's not a given. There will be disagreements among governments about what the treaty should say, and we could talk a bit about things that aren't in it that should be in it, or things that are in it that perhaps politically are going to be difficult and need to be taken out. If we get to that point where governments do adopt the treaty, then the next stage is getting states to sign it and ratify it. And that's not an easy lift either, right? Particularly for a country like the United States, which is very cautious, very slow about ratifying these major multilateral treaties. It took us 40 years to join the Genocide Convention, which you would have thought would be an easy one, right? So, that's another big lift. But I would say that the final hurdle to get over, difficult hurdle to get over, is even if the treaty's adopted, even if a significant number of states ratify it, It needs to be implemented. And there is a problem with implementation where some states join these treaties and they don't follow through in terms of adopting the relevant statutes and so on. So it's a big struggle. It's going to be a struggle to get the treaty done. It's going to be a struggle to get implementation of the treaty. And those are all hard things to do. But I would say, and specifically to the students in the room here, this is what lawyers do, right? This is what we do. We try to make the world, as best we can, a better place, right? And as hard as it may be to accomplish these things, we have to keep pushing. We have to keep the pressure on. And if we only get the glass half full, we grab that part of the glass and so on. So as difficult as all of this is, and I'm not sanguine that it's all going to be simple, my hope is that that it will ultimately be a big success in stigmatizing these crimes and going a long way to both preventing them and punishing them when they occur. I think I'll leave it at that, but I would welcome questions or comments from the audience. We have another 20, 25 minutes, I think. In the back?
Yeah, you mentioned about half the world have statues, and we went through the gray nations. Who are the ones that have great statues and seem to want to enforce it? And has it been enforced? Have they been enforced?
So I'm not sure you could easily characterize the countries that have gold-plated statutes on crimes against humanity. I would say that they do tend to be states that are parties to the Rome Statute, because they've, in joining the Rome Statute, have looked at it, looked at that definition of crimes against humanity and made a conscious decision to absorb it into the national legal system. But I certainly probably many of the European states have successfully done this as opposed to some of the other states around the world. But it's hard to be too dogmatic in saying it's a particular group. Even some of the European states, what they've done when they adopt a national law is allow themselves just to surrender people to The Hague. So they're not really thinking about, we're going to prosecute people here. It's just, I want to be able to surrender to the ICC in the event that I'm requested that I do so. And that obviously is not what we're trying to accomplish with this. So it's a bit of a mixed bag, I would say. Yeah.
So, Sean, a couple of years before your election, colleague from WashU, Layla Sadat, who will be speaking here on February 28th, sort of bookending your presentation, convened a conference with a discussion about the idea for a Convention on Crimes Against Humanity at the Carnegie Institute. I think you were there, right?
In Washington, yeah.
Washington.
Yeah. Mm-hmm.
And ultimately from that, there was a very early draft of the convention that you ended up continuing to work on. My question is, how different and in what ways is the convention that has gone through the ILC from that convention that the academics proposed?
Yeah. So I'm glad you raised that because I need to highlight that the idea of doing a treaty of this kind is not unique to me. I didn't come up with this idea. In fact, in the mid-1990s, Sharif Bassiouni wrote an article on the need for a convention on crimes against humanity. That, I think, is the first time it was talked about in a very public way. And then Layla Sadat, Washington University, sort of picked up that idea in the 2010 timeframe and went so far with it as to even convene a group of largely academics, some practitioners as well, to draft a convention. I guess I'd say two things in terms of how it differs from what the ILC has done. One would be it's much longer, much more fulsome, covers a lot of things that you know, may just be part of a drafting process when you get a bunch of people together and there's good ideas coming from all directions and everything gets in and not so much gets taken out. Whereas at the ILC, our approach is, as I said, to be thinking like lawyers, what would be our wish list of things and so on, but with the political antenna up as well, because we have very much in mind that we're not just a standalone body. We are essentially the United Nations legal think tank. In other words, the General Assembly is our client. We don't just do stuff that we think's great and then we put it out there and we forget about it. We send our things to governments, we get their reactions, and certainly if we want it to be a treaty, they are the ones that will make it happen. So with that in mind, we were often talking amongst ourselves, is it a good idea to put a particular thing in or not? And if we had a sense that by putting it in, we would lose, say, 10 countries, and we put something else in and we'll lose another 10 countries, and before you know it, we're down to only about 25 or 30 countries that would support this thing. We didn't want to do that. So I would say ours is more streamlined. It's more basic. It attempts to get at just the heart of the things that we thought needed to happen. Not a lot of bells and whistles in it. Some might say it doesn't do enough. And that's a fair criticism, and it may be that we misgauge this, but basically, I think if you look carefully at what we've done, it's, you know, bread and butter stuff. The other thing that's maybe a little bit different is we not only draft the articles, but we write a lengthy commentary justifying why we wrote it. And Layla's project didn't do that. So it's great to see the draft articles, but you're not always sure why is this in. Ours, you can read the commentary in conjunction with the draft articles, and it's a good way of seeing what motivated us to do what we did. Yeah.
You mentioned earlier that one of the draft articles focuses on aiding and abetting against humanity. So exactly how broad of a scope does it include propaganda, or is it more actual action?
Yeah, so it's draft article 6, paragraph 2C, and it refers to having to criminalize ordering, soliciting, inducing, aiding, abetting, or otherwise assisting in or contributing to the commission or attempted commission of the crime. Those words are cherry-picked out of the Rome Statute. So we were basically trying to mimic what we saw in the Rome Statute in terms of this sort of ancillary modes. One interesting issue embedded in your question, I think, is the word inciting is not used there. And incitement to the crime is a very important thing. If you're familiar with the Rwandan situation, the radio broadcast that went out, you know, killed the Tutsis, this sort of a thing. There's no question that's an important issue. We didn't include that particular word here, but we say in the commentary, in our view, inciting is embedded in this string of words. I would say some members still would like to see inciting in there. And, you know, maybe in the second reading, it will pop in there, or if it goes to a diplomatic conference, maybe the states put it in there. I myself think it's in there already, and we're trying to stay in sync with the Rome Statute, so that's where we are right now, but it is an important issue. Yes, sir.
Thank you. So about maybe I have like two questions, but they're not really related to this conference. Maybe it's related. So the first one is the claims for the losses and damages and injuries from the Eritrean-Ethiopian war result for damages relief with rules of law. So are these rules are general rules or under international law, or is just like for this particular war? And the second question is, under the ICC statute, there is 4 crimes. They're mentioned, stated on the ICC statute itself. It's the war crimes, crimes against humanity, and genocide and aggression. So, don't you think that these crimes are included in crimes against humanity, or there's a fine line between them? So that's it. Thank you.
Okay. Okay, so that first question was definitely outside the scope of the overall talk, but I'm happy to answer it. For those of you who aren't aware, Ethiopia and Eritrea had a brutal war from 1998 to 2000, where there are all kinds of war crimes committed and various acts of aggression and so on that cause considerable loss, damage, or injury. They set up, as a part of the December 2000 peace agreement, an Ethiopia-Eritrea Claims Commission, which was charged with receiving claims by both sides against the other for loss, damage, or injury resulting from a violation of international law. The commission held a series of about 9 arbitral hearings. They issued probably 24 arbitral awards, and they addressed large-scale compensation that was owed by both sides against the other. The basic question was, can this be viewed as sort of general international law that they're applying, or is it law that's unique and specific to the Claims Commission? I think the answer is a little bit of both. The commission was driven by its own mandate, so it only had certain things it could and could not do, and therefore you need to pay attention to that mandate when you say, well, they didn't offer compensation for the harm to the military itself, even though one side had proved the other was the aggressor, and you would have thought if you violated international law in the form of an act of aggression, then the other side should be able to claim for the bullets they had to expend and the tanks that were messed up in defending themselves. The commission, that wasn't within the scope of their mandate. So that's out. You wouldn't want to extrapolate that to general international law. Having said that, 95% of what they did was apply the Hague and Geneva Conventions, human rights treaties in some instances, and so on. And I think you probably would cite to it as a source of international law. I've certainly done so in my practice. I'm currently representing a country before the International Court of Justice, and we're citing to the commission. Your second question, aren't the sort of crimes within the jurisdiction of the International Criminal Court all crimes against humanity? I think the answer is no. We define these crimes in very different ways. So crimes against humanity, widespread or systematic attack against any civilian population in the form of specific types of acts, murder and so on, whatnot. Crime of aggression is something different, right? It's not the same thing. It's basically violation of Article 2.4 of the Charter at a sort of heightened standard if you follow the Kampala amendments. So you could conceivably have an act of aggression that involves no crime against humanity, right? One country invades another, but treats the civilians fine, right? I think it's entirely plausible you've violated the crime of aggression, but not crimes against humanity. And likewise, genocide, it's a very specific type of crime. I do think that if you were to prove a crime of genocide, in all likelihood, you can prove a crime against humanity. So there's some, but the obverse is not true, or the converse is not true. You might have a crime against humanity that's not genocide. In fact, the striking thing about Cambodia is, despite the deaths there, in all likelihood, you wouldn't be able to prove it's genocide because of the way that crime is defined. So anyway, I think they are very different things.
Oh, sorry. I just wanted to make a point that we're eventually webcasting this, so
Okay.
in order the questions to be caught, they need to be spoken into
Okay.
the microphone.
Okay.
So for whoever raised their hand, I can bring this to you.
Very good. Maybe down here in the front.
I'm not familiar with a lot of mechanics on how this works, but how do you, I'm interested in enforcement and prosecution. So let's assume that the treaty is passed, and you mentioned the North Korean leader, and you believe there's crimes against humanity there. How does the treaty or the world prosecute the
Yeah.
person who's
Yeah.
committing these crimes?
No, it's a great question. So, let's assume the bad actors are still in their own country, are still in power. How does one get their hands on it? And I think the answer is not very easily, right? That probably something has to happen. There could be an internal rebellion of some sort. There could be an invasion that happens of some kind and somebody falls from power. So when we think about Saddam Hussein falls from power because of an invasion, Hussein Habre, I mentioned, flees from Chad as part of a unwinding of a crisis there. You're going to have to probably have things along those lines. Now, it's always possible when someone travels from one country to another that they might fall into the hands of somebody who wants to prosecute them. But you know, the point in part embedded in your question is a very good one, which is that at least for some of the atrocities I've talked about, it's not obvious how today, even if all of these laws are in place, automatically things happen. One likes to think there will be some amount of deterrent effect if we make the web a little tighter, a little bit harder to escape. But ultimately, you may well have to have something happen in order for those leaders to be tagged. Yeah.
Thanks for a great talk, Sean. I'm wondering if you could go back to the decision to lift the language from the Rome Statute about defining crimes against humanity, and in particular, this idea that it has to be done in conjunction with a systemic attack on civilian populations. And some of the examples we've talked about, Cambodia comes to mind, North Korea, I think even the Holocaust took place without necessarily an attack on civilian populations, right? There wasn't necessarily an army attack. It was instead some sort of domestic feature or domestic government's choice to send people to death camps or whatever it was. So in light of that, why would you, and I know it was in the Rome Statute and there's a certain valence to doing that, but given that it also excludes a lot of acts that I think most of us would consider a crime against humanity, why did you guys decide to continue to have the attack nexus in the definition of crime against humanity?
Well, my understanding, at least, of the word attack would pick up at least some of your examples there. So a government that rounds up civilians and takes them off to death camps and exterminates them, that is an attack on a civilian population. I don't think there's any disagreement about that. So you do need it to be widespread or systematic. You know, there's got to be some amount of either numerical gravity to it or some sort of pattern of conduct that's taking place, something of that nature. It's any civilian population. It doesn't have to be the whole civilian population. It could be you're just going after parts of it. There are some tricky questions. You know, let's say that non-state actors are targeting military and police personnel that are not on duty, let's say, you know, in their homes or whatever. Is that an attack on civilians or is that not civilians? There's questions of that kind. But, you know, I mean, my sense of it is that that concept of widespread or systematic attack would pick up things that go well beyond just a military shooting guns or, you know, artillery or whatever at civilians. So, yeah, I'm ignoring this side of the room, so maybe we should bring the microphone down here.
Maybe I can start with that. How do you deal with duress with respect to aiding and abetting? And the second question, if I may ask, is what are other topics that the ILC is dealing with right now?
Mm-hmm. So the issue of duress is an interesting one. Can a alleged offender plead as a defense to culpability that they were under duress? It might happen in an aiding and abetting context, or it might just happen that, you know, I didn't want to shoot the civilians, but they put a gun to my head and told me to do it. That's the Erdemovich scenario at the Yugoslav War Crimes Tribunal. Young boy, 17 years old, at Srebrenica, You know, he's a Bosnian Croat. He's not a Bosnian Serb. The Bosnian Serbs say to him, shoot the civilians. He says, I don't want to do that. They say, you do it or you can line up with them, right? One of those scenarios. And his defense when he gets to the Yugoslav War Crimes Tribunal is, I was under duress. I shouldn't be found culpable. The Yugoslav War Crimes Tribunal in that context says, well, we don't have any guidance in our statute, so we have to look to other sources of international law. They look to the source of international law known as general principles of law, where they tried to figure out in national legal systems how is this addressed. As it turns out, in common law systems, for the most part, we do allow duress to act as a exculpatory defense. But in civil law systems, they don't when it's an issue of killing. So they couldn't find a general principle of law that they would deal with in the tribunal. Therefore, they did not let Erdemovich use that as a defense. They did, however, believe that there was a general principle of international law that allows you to use it in mitigation of your sentence. And so they allowed it to come in at that stage. We are silent in the draft articles on that issue. And the reason is that we are very conscious of the fact that we are trying to get states to alter their national criminal laws. And yet they have to operate within their existing national legal system, right? So you could have asked the question instead about something like death penalty, right? Do you allow the death penalty? Do you prohibit the death penalty? We've stayed away from those kinds of things. We want to make sure that crimes against humanity are criminalized. We want to make sure that you exercise jurisdiction over them and so on. We aren't trying to dictate to states the things that surround that. I don't know if ancillary is the right word, the issues like a duress or the nature of the sentencing and all those sort of things. We've let the national legal systems operate in whatever way they do. So if you're in a particular country where duress is a defense at a particular stage in the process, then it would operate in that way. The International Law Commission right now has about, I think, 9 topics that we're working on. I guess I won't go through all of them, but I'll set up sort of categories. So one set of topics is focused on systemic aspects of international law, by which I mean we have a topic on how do you identify customary international law? What's the process for figuring out that a customary international law rule exists? And within that box also, we have a couple projects refining issues relating to the law of treaties, such as on provisional application of treaties and on interpretation of treaties. It's a deeper dive into our earlier project from decades ago, which turned into the Vienna Convention on the Law of Treaties. So there's those systemic type projects. Then there are some projects like mine that are focused on subject matter areas, crimes against humanity, protection of the atmosphere, armed conflict and the environment, rules that cross over between international environmental law and the law of war. And do we have a third category? Maybe we don't. I guess maybe it's the cross-cutting systemic ones, and then there's the more focused. I probably should have put in that systemic category a new topic we're doing on jus cogens. Students in the room, if you've taken international law, might be getting excited about this, because jus cogens is this cool peremptory norm thing that strikes down all other rules, and the only problem is we're not quite sure how to figure out what they are. But it's a neat concept anyway. So anyway, lots of interesting topics. It's been a lot of fun for me to learn about these issues that I hadn't really thought about before.
In terms of prosecution under the proposed convention, is there the functional equivalent of either preemption or double jeopardy, so that if a member state arrests, indicts, prosecutes, and acquits a defendant, is that the end of it?
So there is, as a matter of international law, this idea of no double jeopardy. What's interesting about it is in the context of international law, what that is focusing on is if they've been prosecuted in some other international tribunal, they can't be prosecuted again in some other international tribunal, or if they've been prosecuted in national law, they can't be prosecuted before an international tribunal. That concept of no double jeopardy actually doesn't speak to the issue of prosecution in one state and then a second prosecution in a different state, different country entirely. We do not have anything in our convention on this. We've talked about it somewhat. I would say, and maybe this is a good closing comment, we are very much guided by the way these kinds of treaties have been written with respect to other crimes. So we do have a convention against torture, we do have a convention against enforced disappearances, we do have a genocide convention. We very much have been looking at those treaties in trying to figure out what should be in our treaty. And none of those treaties have anything on double jeopardy, so we've decided not to put it in ours. Again, that's a design choice. It may not be the right decision. I'd welcome thoughts from many quarters about things we should be including, but we're allowing background rules of international law to regulate matters like that rather than the treaty itself. Yeah.
Please join me. Sean's presentation showed us how one individual can really play a significant role in creating new international law, and that's the reason we've given him our Humanitarian of the Year award. Again, thank you, Sean.
Thank you, Michael, very much. Appreciate it. Thank you.
I hope you'll come back on February 28th when we'll bookend this by hearing from Layla Sadat and seeing her documentary about the process for creating a convention on crimes against humanity. Please join